Welcome to the inaugural episode of the Justice Brief. I'm your host, Saurav Das, and I couldn't be more thrilled to embark on this journey with all of you, bringing you a closer look at the pillars that uphold our societal order. In this digital realm where information floods our screens, the Justice Brief stands out as your beacon of legal clarity. Whether you are a legal enthusiast, a curious citizen, or someone simply navigating the intricacies of justice firsthand, this show is your compass through the complex terrain of law and courts. On the Justice Brief, we transcend mere headlines and dive deep into the heart of legal matters. From landmark court decisions to the latest legal controversies, we will leave no stone unturned. But more than that, I will delve into the human aspect of law, the stories of individuals, the struggles, and the triumphs that shape our legal landscape. But before we delve into the depths of jurisprudence, let me take a moment to express my gratitude to The Wire for this incredible opportunity. Together, we aim to illuminate, educate, and spark meaningful conversations around the very foundation of our civilization, justice. So buckle up and be prepared to be informed, inspired, and empowered. Welcome to the Justice Brief. In this video, we will talk about one of my most favorite topics, the Master of Roster. Simply put, it is the privilege and the administrative power of the Chief Justice of a court to constitute benches and allocate cases at their absolute discretion. This is called the Master of Roster system. Experts say that this power is completely opaque, it is arbitrary, and lacks any guidelines to keep a check on the misuse of this discretionary power. So of course, due to the lack of any transparency, speculations will arise. Sometimes there are even genuine concerns about potential government influence whenever bench assignments align with government interests. There is a perception that sometimes in matters where the government has high political stakes, those matters are carefully assigned by the Chief Justice before those judges whom he may perhaps know will grant a judgment one way or the other. This system is not explicitly laid down in any law or the Constitution, but has evolved as a matter of convention and the Supreme Court's own judgments over the years. You see, someone has to ensure efficient functioning of the court, right? The workload management, the expertise of judges in specific areas of law, and balancing the composition of benches to reflect diversity and representation. So who does that today? That burden falls on the Chief Justice of the court. But like I said, critics argue that the system is susceptible to favoritism, where certain judges or benches are consistently assigned high-profile or politically sensitive cases, leading to perceptions of bias or unfairness. It's not just critics, you see. In January 2018, the infamous press conference by the four senior-most judges of the Supreme Court after the Chief Justice conveyed similar concerns. At that time, the concern was that the Chief Justice of India, Deepak Mishra, was assigning certain sensitive cases to junior judges with a political bias by passing them. The judges were concerned that somebody from the outside was controlling the Chief Justice. You see, now more than 6 years have passed since that first ever press conference of sitting Supreme Court judges raising these very serious questions. All is not well in the Supreme Court, they had said. So how much has the system improved? One can argue that apart from cosmetic changes, not much has improved. On the contrary, things seem to have taken a new turn for the worse. 4 months ago, in December 2023, I had reported for news website Article 14 that at least 8 politically sensitive cases made their way to a bench either headed by or consisting of one particular judge, Justice Bela Madhurya Trivedi. Trivedi, the first woman judge from the Gujarat High Court elevated to the Apex Court, served as the law secretary in the government of Narendra Modi, who was then the Chief Minister of Gujarat from 2001 to 2014. So why is it strange that matters were being listed and even pulled away from senior judges and shifted to a judge who was then only the 16th in the rank of seniority in the Supreme Court? Because this transfer business of the cases, of course under the watchful eyes of the Master of Roster, Chief Justice D.Y. Chandrachud, was in violation of the Supreme Court's own rules and age-old convention. The 2017 Supreme Court Handbook on Practice and Procedure and Office Procedure says that cases should be retained before the senior judge before whom the case was first listed, or listed before a judge hearing a similar case. So, for example, if Judge A is already hearing a case, then that case should continue to be heard by that same judge until the very end, except if that judge retires or withdraws from the case or is unavailable. This is what the rules say, and this has been the court's practice. But in this investigation, I found two things which raise serious questions about the exercise of powers by the Master of Roster. First, I found that at least 7 of the 8 politically sensitive cases were shifted without any reasons from senior judges to the bench headed by Justice Trivedi. At the end of this video, I'll tell you why senior lawyers too have objected to such sensitive cases going before one particular judge at the Supreme Court. Now, the 7 cases were: 1. Umar Khalid's bail plea; 2. Petitions challenging the constitutionality of certain provisions of the Draconian Unlawful Activities Prevention Act (UAPA); 3. Petitions challenging dismissal of a fresh investigation against former Tamil Nadu Chief Minister Edappadi K. Palaniswamy for alleged involvement in a highway tender scandal; 4. A petition connected with the Central Bureau of Investigation's probe in a disproportionate assets case against Congress Party's Deputy Chief Minister of Karnataka D.K. Shivakumar; 5. Bail plea of Bhima Koregaon violence case co-accused Mahesh Raut; 6. Andhra government's challenge to the grant of regular bail to former Chief Minister Chandrababu Naidu in the alleged 370 crore skill development scam; and 7th, the jailed Tamil Nadu government minister Sendil Balaji's medical bail plea. Let me explain one of these cases so you can understand how matters were shifted against the rules and conventions. Let's take the case of Deputy Chief Minister of Karnataka D.K. Shivakumar. The CBI had challenged a 12 June 2023 decision of the Karnataka High Court that granted an interim stay on an investigation against Shivakumar in a disproportionate assets case. The case was first listed on 22 September before Justice Aniruddha Bose's bench, then consisting of Justice Trivedi as the junior judge. However, on the third date of hearing, 7th November, the case was pulled out from Justice Bose's court and listed before a Justice Trivedi-led bench, despite Justice Bose not having retired or made a specific order to withdraw or to list it before some other bench. Just 3 days after Shivakumar's case was listed before Justice Trivedi's court, a final order was passed in the CBI's petition. Although Justice Trivedi's bench, consisting of Justice Sharma as well, refused to interfere with the High Court's interim relief to Shivakumar, it asked the High Court to decide the CBI's application for removing the interim stay on Shivakumar's investigation, preferably within 2 weeks. The second thing that I found was this. The rules also say that if Judge A is already hearing a case that is similar to another fresh case that has been filed, then the matter should go to the same judge. Former Supreme Court Judge Justice Madan Lokor, in conversation with Article 14, explained why this rule is important. He said that when he was in the Delhi High Court, if there was a case in which there were 5 accused and one of them filed a bail plea, the FIR number should be mentioned in the listing pro forma so that subsequent bail appeals filed by other accused go before the same judge. He said that this was a salutary practice intended to avoid getting conflicting orders in the same case, and more importantly, to avoid bench hunting. Otherwise, accused A may get bail and accused B may not. It's the same in the Supreme Court. He said that he does not understand why a case arising from the same FIR should go before different judges. It should go before the same judge who is dealing with that FIR. In my investigation here, I found that 4 of the 8 cases in which facts of the matter were similar to other cases already heard by other judges were not listed before them, but listed before a bench consisting of Justice Trivedi, and in some of them even later transferred to a bench headed by her, of course without reasons. The 4 cases are: number 1, the NIA's challenge to the grant of bail to Bhima Koregaon co-accused Mahesh Raut; number 2, former Chief Minister Andhra Pradesh Chandrababu Naidu's petition challenging the High Court's decision to not quash an FIR against him; Number 3, Andhra government's challenge to grant of regular bail by the High Court to Naidu. And 4, the jailed Tamil Nadu government minister Sendil Balaji's medical bail plea. I'll explain very briefly what happened in one of these cases, Mahesh Raut's case. Raut, who is a researcher and forest rights activist, was arrested in June 2018 by the Pune police for his alleged connection with the violence that broke out on 1st of January 2018 in Bhima Koregaon near Pune. In September last year, the Bombay High Court had granted bail to Raut, who had already spent more than 5 years as an under trial in jail. The court stated that it found no reasonable grounds for believing that the accusations against the appellant were prima facie true. He and others have been charged under the draconian UAPA, and this law makes it very difficult to obtain bail. The court, under the UAPA, is asked to deny bail if it prima facie, meaning based on first impression, believes that the case against the person is true. The burden to prove that it is unreasonable for the court to believe the accusations made by the agency are true falls on the accused. You are guilty until proven innocent. More importantly, the law says you can only rely on the police version, the case diary and the police report to prove this. Coming back to Raut's case, the NIA filed an appeal against this grant of bail before the Supreme Court. This is where it gets interesting. Rules and convention, like I said, say that a judge who has dealt with a similar matter must hear the same case. And so the matter was first listed before Justice Aniruddha Bose on 27 September. He was then sitting with Justice Bela Trivedi. Justice Bose, about 2 months before this, granted bail to 2 other co-accused in the same case, Vernon Gonsalves and Arun Ferreira, considering their long period of incarceration. Now, the next time the matter was listed on 6 November, the bench directed the case to be listed on 28th of November. But later, the case was pulled out from Justice Bose's court and shifted to Justice Trivedi's courtroom, without Justice Bose having made any order to that effect. So why is it that Mahesh Raut's bail case was shifted from Justice Bose's bench? In the beginning of this video, I told you that I'll tell you why such cases are being shifted before one particular judge, Justice Bela Trivedi, by the Master of the Roster, Chief Justice of India, despite knowing that it does not bode well for the institution. Senior lawyers like Dushyant Dave, referring to this shifting, have said that justice is sometimes skewed. Let's look at what happened in these 8 cases when they came up before Justice Trivedi. In the Tamil Nadu case, Justice Trivedi-led bench dismissed the Tamil Nadu government's appeal to initiate probe against Mr. Palaniswamy, who belongs to the AIADMK, that was, until September last year, an ally of the Bharatiya Janata Party. In the UAPA constitutionality challenges, the cases were withdrawn after Justice Trivedi's bench asked if the PILs would not be proxy litigation. Sensing that the bench was not inclined, petitioners withdrew with the permission to approach the High Court. Umar Khalid withdrew his bail application, stating that we will try our luck in the lower court. Isn't this a vote of no confidence in the bench? In D.K. Shivakumar's case, although Justice Trivedi's bench did not agree to the CBI's appeal to vacate the stay on investigation granted by the High Court, it expedited the hearing of the same request pending before the High Court. Justice Trivedi's bench has not listed Mahesh Raut's case after 18th January this year. The stay on his bail continues even as other co-accused have been granted bail by another bench, most recently Shoma Sen. In Chandrababu Naidu's case relating to quashing of FIR, Justice Bose ruled in his favor while Justice Trivedi ruled against him. The matter is still pending for the third judge to break the tie. In Naidu's second case, the challenge by Andhra to the High Court granting him regular bail, Justice Trivedi's bench had pushed the hearing to 16 April. Naidu on 9 March announced his tie-up with the BJP for the general elections. And lastly, Sendil Balaji's case. Justice Trivedi's bench was not inclined to grant him medical bail while stating that Balaji's sickness is not serious, with Justice Trivedi taking support of a Google search results to conclude that Balaji's sickness can be cured by medication. Balaji's lawyer sought to withdraw the medical bail plea and apply for regular bail at the Madras High Court, to which the bench agreed. Justice Trivedi is or was also part of benches in several other politically sensitive cases. Arvind Kejriwal's first challenge to his arrest by ED, which he withdrew on the same day. Petition filed by K. Kavita, MLC of Bharat Rashtra Samiti BRS and daughter of former Telangana CM K. Chandrasekhar Rao, challenging her arrest by the ED in the same case, the 100 crore Delhi excise policy case. In the Vijay Madan Lal Chaudhary reconsideration case, which asks for the court to reconsider its earlier judgment upholding the wide powers of the ED to arrest, remand, etc., termed by experts as a judgment that severely hampers the liberty of citizens. It is for these reasons and the ultimate fate of the cases that make it before Justice Trivedi that senior lawyers have asked through open letters to the Chief Justice of India, Chandrachud, to turn more of his attention to these issues, even stating that this does not augur well for the institution of Supreme Court of India under your leadership. Institutionally, Chandrachud's court has not directly addressed these concerns. What it has done is 1. Used anonymous sources to rebut the reports by stating that Justice Trivedi is perceived to be a strict judge and relief in such cases therefore comes more difficult. And 2, the Chief Justice of India himself stating that he would not allow lawyers to decide which cases go to which judge, a demand never made by anyone. The issue here was of transfer of cases in violation of rules and convention. In doing these, the master of roster escapes from giving a proper response, taking corrective actions and holding himself accountable for a pattern that is now very evident. People's faith in the system is a casualty in such cases. The January 2018 press conference of the senior judges raised the issue of selectively assigning cases to a junior judge with political bias. Today, the issue has become graver as sensitive cases are being withdrawn from senior judges and transferred to one particular junior judge. Experts have said that the master of roster has no powers to withdraw cases from a judge, akin to withdrawing judicial work after they start hearing a case. The role of the master of roster is to decide the roster, decide the combination of benches, put them in place and leave it at that. And that's it for today. Don't forget to like this video and share your thoughts. I'll see you all very soon. Until then, stay curious, stay informed, and remember, the law matters.